The probate court process. In its most basic form, the process of appointing a fiduciary will begin with a person who is in need of community-based behavioral health services but manages to live in the community with any number of providers involved in their lives. Treatment of mental incapacities is a balance between this community-based living and community-based treatment. Persons with mental incapacities often experience decompensation. This may be due to any number of factors. Decompensation leads us to three potential outcomes. The crisis can be de-escalated, the individual can be redirected, and the prescribed treatment plan can be continued. Decompensation can lead to criminal behaviors, which leave authorities no choice but to detain an individual for his or her own safety and the safety of others. Finally, decompensation can lead to hospitalization, involuntary commitment, and the process we describe as the probate court revolving door. When an individual is determined to be in need of prolonged hospitalization due to the severity of his or her illness, the hospital must file the appropriate application in order to legally detain an individual against their will. Upon receipt of this application, the probate court must schedule a hearing and appoint an attorney for the individual who is the subject of the petition, AFR. A formal hearing is held, at which time the respondent must be afforded all due process rights, including the right to cross-examine any witnesses. The burden is on the petitioner or applicant to prove respondent should be involuntarily committed to the facility because he or she is gravely disabled, a danger to self or others, and there is no less restrictive placement available. In other words, the petitioner must show that, despite their best efforts and the utilization of a multitude of resources and corrective planning, the respondent needs to be confined against his will because doing so is in his best interest. Having made the appropriate findings in a recorded formal hearing, the judge of probate has the ability to involuntarily commit the individual to the facility. Hopefully, treatment in the facility will have met with success and discharge planning will be implemented in the form of a community-based treatment plan. Very often in this process, it is determined that there is no third party available to assist the team in reaching consensus as to a plan. Given the appropriate characteristics of each case, the hospital or other interested party may deem it appropriate to file an application for involuntary appointment of a fiduciary. An attorney is appointed to represent the individual to be conserved. A formal hearing on the application will be held after legal notice has been made to interested parties. The determination is made as to the need for the appointment of fiduciary. If a fiduciary is in fact appointed, he or she should work with the discharge planning team to secure resources necessary to return the individual back to the community as quickly and as safely as possible.